Stand by with them. I know who these guys are. Come on. Seriously? I know what you just did. Let's go. Step out of the car. That's slick. Both of you, come on. Come on, listen. You know better. We deal with you all the time. Alright?
Like, I'm homeless.
I get that, alright? Alright, I get that.
I don't want to get in trouble.
But you shoplifted. You just shoplifted. Come on. Stop it. Hop out for us.
2 officers detain a man and a woman outside a vehicle after reporting a shoplifting incident. What happens next raises a narrower question. Once handcuffs go on, how far can a search legally go? Start with the stop itself. An officer claiming direct observation of theft does not need proof beyond a reasonable doubt to detain someone. Reasonable suspicion is the standard. An eyewitness observation clears it easily.
What's her name? You seen a cop car sitting right there. You didn't think that we were watching you guys?
I apologize.
Let's go.
I'm in trouble?
Is shoplifting a crime?
Can you please just... I never got in trouble, like...
Can we just return the items?
No, because, you know, would you return items if you didn't get caught? Hop out for me. Come on. Let's go. The quicker we get done this, the quicker you guys get out of here.
So now what?
Well, it's just going to be shoplifting.
So now what?
Hand me your stuff. You're going to come back with us. Come on, I was so cool with you. Why are you doing this shit? Right, come in the back of the car. Danielle, you got cuffs? Come on. Who's this cat with you? Yeah. For real, bro? We try to help you guys out. You're doing this bullshit? Yeah, for. Come on. I'll take it. I'll take it.
Anything in your pocket that you shouldn't have.
Do you want any of this shit to come with you? Come over here.
No, that's not mine.
Is this bag yours?
Just leave everything down.
That's mine. That's not mine.
What's up, man?
That's not...
It's just a mess, and I don't know who's to.
Do you got shit in there that you shouldn't have?
No.
I'm not worried about that.
No, and I don't, like, I just don't want everybody touching it. Like,
Well, I seen her carrying this bag.
Okay, well then...
Carry this bag.
oh, the bag.
That bag was in there.
Boss, if you don't belong here, you need to go.
Sorry.
Hit the road, brother. Hit the road.
If you don't-
Peace out.
Maybe next time you win.
Brother and sister, I got 200.
Can I just give him a kiss real quick?
He's probably gonna come back to the station. Yeah, you can give him a kiss. Over here, though. Over here. Over here. You can slide over. Come on. We're going back to the police station, yeah. Come on.
She's got pipes in here.
Terry versus Ohio. 1968. Set that standard. Specific, articulable facts. Not a hunch. An officer watching a theft occur satisfies that requirement without much argument. Direct observation actually pushes past reasonable suspicion into probable cause. That distinction matters. Probable cause is the higher bar, and it is what justifies an arrest, not just a brief stop. Once probable cause exists, the search that follows is not a separate legal event. It is governed by a different rule entirely, one that gives officers considerably more room than a simple frisk. United States versus Robinson. 1973. When there is probable cause to arrest, officers may search the person and any containers on them incident to that arrest. No warrant required. That rule exists for a practical reason. officer safety, and evidence preservation. A person about to be placed in a patrol car cannot be left holding something dangerous or something that can be destroyed. Robinson did not limit the search to weapons. It extended to anything on the person, including closed containers. That is the legal basis for searching a bag someone is carrying at the time of arrest. Now the paraphernalia question. An officer finds items resembling drug pipes while searching a bag already lawfully opened under Robinson. The next legal test is whether that discovery was immediately obvious. Minnesota versus Dickerson, 1993, created what is called the plain field doctrine. If contraband is immediately recognizable during a lawful search, it can be seized. No separate warrant needed. The word immediately is doing real work here. Courts have struck down searches where an officer had to manipulate, squeeze, or investigate further before identifying an object. Recognition has to be instant, not deduced. In this footage, the bag was already open under a valid Robinson search. Pipes are visually distinctive. That combination is close to a textbook application of plain view rather than plain feel specifically.
Put them in your car when we get there.
I got bags in my car.
Do you have the merchandise?
Yeah.
Do you want to put them both in your car and I'll get them?
Yeah, that's fine.
Alright. We're gonna walk back. They're all the way to that car. Okay. Ready?
I didn't search in there. Over here, guys.
Is this all from CBS?
What's her name?
Is that or not?
Probably. We gotta get there.
So you know you're being audio and video.
Yeah. Close. You stare right at me walking down the store. Put one on this side. Did you already check her?
I did. I gotta get her piped out.
You got pockets or anything?
Huh?
You got pockets or anything?
No.
You got anything in your waistband? They're right in there. Did you have a phone on you too?
Yeah.
What's in here? Come on, man.
How do I eat?
I get
Ain't
that.
nobody gonna feed
Listen,
me?
I get that. But
You don't get it, because nobody's
no,
gonna
I understand it
feed
because you do gotta eat. All right, I'm not worried about that right now. But don't do this shit in my town. Come on, we treated you guys good last time.
I haven't eaten in 2.5 days.
I'll give you some food.
I'm hungry.
All right, I'll give you food.
I'm thirsty. I don't have gas in my truck. What am I supposed to do?
I get that. All right, I get that. Okay, I understand where you're coming from, but like I said, just do this in a different fucking town because we take care of you guys. You know what I mean? Brian Sanders.
I just don't have a cigarette. What do you need?
You need a cigarette? You want food? You should just still. Is this from there? Be honest with me.
Yes. What period?
I thought they were underwear. Oh,
It's
period.
not like I'm even grabbing shit to fucking sell.
Yo,
Like, I
I know. Listen, if you were to get caught, these are probably the best two officers in our department to get caught by. Because they're the most understanding. So. You're hungry? You eat Twizzlers when you're hungry? Get something with protein in it, bro. Come on.
The rest of that is just my stuff. That's the only place I put the stuff.
Buy more than- Come on, man. Come on. You could at least tell me that.
I told you the rest of this shit is enough.
I bet. I know that ain't stolen, right? I believe that.
Literally, I put my shit in that bag. That's it. All the other stuff is my stuff. Yeah.
It's not, you know what? The funniest thing is that's not the first time. Be surprised.
You can smell it.
No, I'm full. I just ate.
My family, like, oh wow, for paying family dollars. I had to stop working.
I'm like, what?
I don't know if I thought a lot. You're taking this, right?
I got to figure out this from the outside.
Okay. I'm clear from leaving Cal. I'll be out at 885 Cal Street, Parking.
And you didn't find any bad stuff on me, right?
Nope. He's probably in the truck still, right? I like it better that way. What's up, dude? I'm just gonna check. I'm just gonna check your back of my hand. Right? Is that your boy? You know that dude?
I don't know that fucking dude. You couldn't even spit out the fucking words.
Will we be able to get a cigarette?
Yeah, he wants to get back to the station. I gotta process you and stuff first, and then. I think her boyfriend's picking you guys up.
Our boyfriend.
Your boyfriend is it? 25 on Central. 2 females under heading 10-1, starting 67.4. If he snitch? Sounds good to me. 11 Central, 10-1, I think 67.6. Oh, yeah, no problem. I'm a bank too, you didn't know that? Definitely got nothing in there. It's good. Over here.
You wanna hear something?
Oh, very
It's so nice.
Have we dealt with you before? You look familiar.
That'll make the ones on the dance floor.
Take a left. Then I'm
All right.
No, other left.
Oh.
Have a seat on them 2 chairs.
What chairs?
Right there.
Why can't we get the cushions?
Wait, you're not gonna be there long. That has a cushion on it anyway. That one's dirty. It's old. You don't want that one.
I want that one. It's more.
Now consider the questioning. An officer asks if there is anything in the bag that should not be there. This sits in a gray area worth understanding. Because not every question during an arrest triggers Miranda. Miranda versus Arizona, 1966. Applies to custodial interrogation aimed at eliciting an incriminating statement for use in court. A routine procedural question during a search is generally treated differently by courts. The line courts actually look at is intent and function. Is the question designed to secure a confession, or is it designed to manage a search safely? Those two purposes get treated very differently. Asking someone to disclose contraband before a search often serves a safety function. It gives the person a chance to speak before an officer's hands, find something unexpected. That is not interrogation in the constitutional sense. Where this could get contested legally is if any statement made here were later used at trial as an admission. Voluntary disclosure without Miranda warnings still carries weight, but it invites a defense challenge. A defense attorney would likely argue the individual was already in custody, meaning restrained and not free to leave. At the moment that question was asked, that single fact could reframe the entire exchange. If a court found this was custodial interrogation without a Miranda warning, any statement obtained would likely be suppressed. The physical evidence itself, however, would probably still stand under Robinson. That separation matters. Suppressing a statement does not automatically suppress the evidence found independently through a lawful search. Courts treat these as two distinct legal questions, not one combined outcome. On officer discretion, nothing in the law requires an arrest for every shoplifting incident. Charging decisions, citation versus custodial arrest, remain within an officer's judgment based on circumstances and department policy. Here is the practical lesson. Probable cause from direct observation is difficult to challenge later. If you are stopped after an officer claims to have witnessed a crime, assume that threshold has already been met. Second lesson. A search following a lawful arrest is broader than most people expect. It is not limited to padding for weapons. Bags, pockets, and containers are all fair game once probable cause exists. Third lesson. Silence protects more than people think. Answering a question about what is inside a bag, even a casual one, can become evidence. The right to stay quiet does not disappear just because handcuffs are already on. That is the legal breakdown. If you found this useful, subscribe for more analysis grounded in actual case law rather than assumptions about what police can and cannot do.